Erev Tov from Jerusalem, and great afternoon where some of you are, and I assume others have other time zones. It's wonderful to be together again in another one of the webinars that we are offering jointly, Chidush, Ruach Chidush, Rabbis and Cantors for Religious Freedom and Equality in Israel, J-Plan, the Jewish Pluralism Legal Action Network, and the American Association of Jewish Lawyers and Jurists. And well, by popular demand, we are fortunate to have Professor Rivka Weill with us again for a fascinating topic, which is not only an interesting topic in legal history, but really in contemporary life in Israel this very day. Professor Weill will be introduced by Peter Buxbaum. Judge Buxbaum is the co-chair of J-Plan, of the Jewish Pluralism Legal Action Network, who will introduce her and moderate this. We are recording this session, so it will be available to you shortly after the session for further repeated viewing or sharing with others. And before I hand the leadership of this webinar to Peter, just one announcement. There are two exciting webinars that have already been scheduled for the 3rd, 2 weeks from now, and the 17th, 1 month from now. On the 3rd, we will have Professor Alex Kay of the Israel Center at Brandeis University dealing with a related topic, namely how the notion of theocracy, of Jewish theocracy, came about in conjunction with the Jewish tradition, in conjunction with the State of Israel, and how the issue of Jewish theocracy is still on our agenda today. How does it impact Israel of today? And in a month's time, on the 17th, we'll have another attorney. We'll have Professor Ruth Halperin-Kadari, the founder and director of the Reckman Center at Bar-Ilan University Law School for the advancement of the status of women, who will be discussing women, COVID-19, religion and state in Israel, both general issues in comparison to feminism and the role of women in the pandemic era in other countries, and some more specific issues that have to do with the clash of religion and state in Israel. So with that, Peter, it's your turn. Take it on.
Thank you all for joining us, and thank you, Professor Weill, for agreeing to speak. One of the pleasures of having gotten involved with Hadush and Uri is the studying I've been doing. And when I came across an article on the strategic constitutional jurisprudence of Aharon Barak, I couldn't help but be awed and amazed by the relevance and comparison between what Barak did and what our own Chief Justice did back in 1803. And so I had to reach out to Professor Weill, and we have, I think by internet, become friends. She's a remarkable figure. She's a professor at the IDC Herzliya, but she's visited also at Cardozo, Yale, and Chicago, has lectured in Hong Kong, Oxford, Australia, Chile, and numerous other places. She's done path-breaking work that's been used by the Israeli government and has been brooded about by others on how to deal with kidnapping. More recently, her work was cited by the Israeli Supreme Court in its discussion of the case of the Knesset speaker, and also on the issues surrounding whether an indicted person like Netanyahu can continue to serve as prime minister. So she's got not only academic credentials, but she's very much in in the forefront of debate about current issues in Israel. The last time she spoke to us without notes from an internet hotspot, which was a bravura performance, and we're very lucky to have her back. And with that, I'd like to welcome Professor Weill to speak to us. I have a brief question, which you're free to ignore, Rivka, if you want to take it in another direction. But how did the Israeli Supreme Court, after 47 years of the state's existence, get the power to declare act of the Knesset invalid and override them? And how does its obtaining that power, what does it mean for us today? So with that, one question, I think, which you probably don't even need, let's go. You're muted.
It's a great honor and great pleasure to be here today. And I wanted to thank you so much for the invitation and for the organization. Special thanks to Uri and special thanks to Peter. It's really a great honor. I'm going to talk about the strategic common law court of Aaron Barak and its aftermath on judicially led constitutional revolutions and democratic backsliding. And as Judge Peter Buxbaum mentioned, my lecture today is actually going to be based on an article that is on SSRN. So anyone who is interested in studying more about the matter can access the article. So there is a growing interest around the world in studying constitutional revolutions. How do they come about? What is the dynamics at play? Who are the political actors involved? Do we need special personalities to bring about constitutional revolutions? And at the same time, I think that there is a growing concern around the world with democratic backsliding. We are seeing the rise of nationalism, the rise of xenophobia, racism, vehement attacks against courts, against the free press. And this situation has been exacerbated by COVID-19. And I think that Israel is an interesting case study for both phenomena. It underwent a major constitutional revolution in the mid-1990s with the United Mizrahi Bank decision that Peter has mentioned, that is the equivalent of the Marbury versus Madison decision. But in many ways, it's a much more revolutionary decision than United Mizrahi Bank. So in 1995, we have the court declaring that Israel's basic laws amount to its formal constitution, formal supreme constitution, and that the court enjoys the power of judicial review over primary legislation. And until that decision, we treated in Israel the basic laws as regular laws, and they were passed like any other regular enactment. So we should understand how did this decision come about. Not only did Israel undergo a constitutional revolution, but also many commentators believe that we are witnessing democratic backsliding in recent years in Israel. There are many threats against, by politicians against the Israeli Supreme Court, trying to curtail the court's power, trying to restructure the court. There is a proposal for a general legislative override power that will enable the Knesset to have the final say in constitutional matters. And what I want to do today is actually explain to you, how did the court build judicial power? How did constitutional revolutions, because United Mizrahi Bank is just one of the revolutions, how did constitutional revolutions come about? Why were they legitimate? Why were they effective? And why do we see such backlash against the current court? And the story that I'm going to tell you is in many ways the story of one particular individual. And that in itself is stunning. Right? And the story is the story of Aaron Barak, President Aaron Barak, Chief Justice Aaron Barak. President Barak is famous worldwide. He's one of the most interesting and influential jurists of our time. And he has been able to influence not just Israeli constitutional law, but comparative constitutional law, international law. But what's so interesting is that even though he retired in 2006 at the mandatory age of 70, when you study law in Israel, even today, you study primarily the decisions of Aaron Barak. And this is true not just for public law. This is true also for private law, criminal law. His influence has been remarkable. And the decisions are still the most interesting ones because of their theoretical underpinnings, because of the revolutionary nature. Now, in many ways, Aaron Barak's story is the story of the Israeli state. He's a member of the founding generation of the Israeli state. He's a Holocaust survivor. He hid from the Nazis during the Holocaust. He comes from a rabbinical family, like the grandfather was a famous rabbi. And the Israeli state, right, was born on the ashes of the Holocaust and is still struggling with reconciling the tension between two tenets of its identity, the Jewish nature of the state and the democratic nature of the state. Now, Barak was recognized as a star from a very young age, from the very start. So he becomes the Dean of Hebrew Youth at a very young age. He receives the most honorable prize Israel can award its scholars, its scientists, before reaching 40. Usually you don't get the Israel Prize until you are in the 70s, if at all, and he gets it before 40. This is a recognition of the prominence of his work. He's appointed the Attorney General of the State of Israel, and one has to understand what it means to be the Attorney General of the State of Israel. The Attorney General is both the head of the prosecutorial office in Israel, but he's also the advisor to the government. It has the Attorney General wears two hats. And as the advisor to the government, according to Israeli law, the opinions are binding on the government. So this is an unbelievable position of power within the executive branch. He's appointed the justice of the Supreme Court. And when he's appointed a justice of the Supreme Court, it is already known to everyone that he will serve for 28 years, of which 11 he would serve as the president of the court. So he has a very long time horizon to influence Israeli legal and political landscape, and he utilizes that opportunity. And usually people are not appointed at such a young age to the Supreme Court. And we know already who is going to be the president at the time of appointment, because the Chief Justice, the president, is decided by seniority. Okay, before he starts on the bench, Menachem Begin, Prime Minister Menachem Begin, acknowledging that he is a star, that he is a brilliant scholar, and actually someone who also understands practicality, asks him to draft and help in the negotiations and in the draft of the Camp David peace agreement with Egypt. So even Barak has influence on the peace agreement with Egypt. So in a way, one has to understand the story I'm about to tell you, one has to understand that the influence that Barak has influenced the Israeli society is an influence as a legislator, as an executive, as a judge, and as an academic persona. So about the executive branch, I've already told you, he was the Attorney General, he wrote opinions that are binding. If you were a dean in Israel and you wanted to appoint young scholars to your faculty, you would give a call to Aaron Barak because it's important to hear what is his opinion about the candidate. If you want to be a judge in Israel, you have an appointments committee, and in the appointments committee sits 3 justices of the Supreme Court and always the president of the court. So you need the endorsement of Barak because otherwise it's very hard to become a judge. And he was a legislator in the following sense. Israeli law was actually established on the British mandate legal system. Israel, during its founding, decides to incorporate pre-existing law to avoid chaos, to avoid a vacuum. But later, Israel rewrites its statutes, its law. And to do so, Israel erects different committees that will advise about the law. And Aaron Barak is a specialist of both private law and public law. So he sits in various committees that rewrite Israeli law. For example, corporate law. Corporations are mainly the work of Aaron Barak. So you have to understand that kind of influence as we go about and tell our story. So I'm going to discuss how Barak actually, in a very strategic way, built judicial power in Israel. And I think the decisions I'm going to concentrate on actually bear the following signature, from my perspective. They bear the following signature of Barak. Typically, the constitutional revolutions or the revolutionary decisions were with a disappointing outcome. The petitioners did not get what they wanted. They went home empty-handed, no remedy. But in terms of reasoning, there lies the revolution. Major transformation of Israeli public law. So you see a gap between the reasoning and the outcome. Now, this gap served 2 purposes. One purpose is to ease the tension vis-a-vis the political branches. Because if the outcome is actually denial of the petition, then the political branches got what they wanted. And the bite was directed only towards later administrations, later legislatures, not in front of the court. But this is a very partial take of the story. The other major component from my perspective is the fact that the court is a collegial body. And when you look carefully, and when you read the decisions, you see that Aaron Barak did not master a majority to his reasoning in the various revolutionary decisions. But because the decision was unanimous in terms of outcome, that helped cement in the public mind and also in academia, also the academic perception became that Aaron Barak's opinion is actually the opinion of the court. And you have to understand that people listen more to outcomes, to the bottom line, to the result, than the reasoning. So with these 2 issues in mind, I'm going to tell you the story of some of the revolutions. Now, what is also important for me to share with you is that many of the most important decisions dealt with a particular issue. And that is the draft of ultra-Orthodox men to the Israeli army. So, this is a very open wound in Israeli society. Right? People are obligated to serve in the army, and it's mandatory. It's not a matter of choice. But since the establishment of the state, the ultra-Orthodox men receive special treatment. But by now, the numbers are such and the percentages are such that it's a really major toll on Israeli society. Now, time and again, petitioners approach the court with the question of equality. And what I many times tell my students is the following. We should really thank the ultra-Orthodox men for staying at home. Because while they were staying at home, we got some of the most important revolutions and some of the most important presence of Israeli constitutional law, the type of revolutions, the type of tools Barak established for the court, for the Israeli society in the decisions that dealt with ultra-Orthodox men were much more consequential, were much more important than the question whether the Orthodox men should serve or should not in the army. And you will hear the story. Okay, so with that in mind, let's talk about some of the revolutions. So I'm actually going to start with the interpretation revolution, where I cannot anchor it in any particular decision. There's no exact time when interpretation becomes a matter of purposive interpretation alone. We don't have in Israel debates like you have in the US, where different justices argue: should it be originalism? Should it be living constitutionalism? Should it be textualism? It's only one method of interpretation: purposive interpretation, and that is pretty much the work of Aaron Barak. He did not invent purposive interpretation. Actually, if we look at the court's work already from the 1950s, we see purposive interpretation. Because if we look even at one of the most interesting and important decisions, the Kol Ha'am decision by Shimon Agranat, who was a University of Chicago grad, who was an American. In the 1950s, he gets a case of the following petition. The Minister of Interior decides to shut down communist newspapers for publishing articles that were likely, according to the Minister of Interior, were likely to breach the peace. And the Minister of Interior was using his authority under a British mandatory ordinance of the 1930s. It wasn't an ordinance that was intended to promote democracy, to promote free speech. And Agranat reads into the requirement of likely that the publication will likely cause breach of the peace. He reads into it the requirement that there should be high certainty, high likelihood that the newspapers will actually lead to the breach of the peace. This is purposive interpretation, no constitution, and that is done in the name of free speech. Again, no Bill of Rights, no constitution. Why did Israeli citizens enjoy freedom of speech? Common law made, the court made it up. So we see that purposive interpretation is an important tool already in the 1950s. But it wasn't the exclusive method of interpretation. Barak makes it into the only legitimate method to be used by the court. Now, you have to understand what it means, purposive interpretation. Okay, so if I have an enactment, be it a regulation, be it a statute, be it a constitutional provision, I have to ask the following question as a court. What is the specific, contextual purpose of the enactment? But I don't stop there. I then ask myself, okay, what is the objective purpose of the enactment? And here the court asks itself, what interpretation will best advance the Israeli values of being a Jewish and democratic state? Wow, that's an enormous power, right? Here the court has a lot of room to maneuver and to advance the values that is important to the court. And if there is a gap or if there is a contradiction between the specific purpose of the enactment and the objective purpose, then we should give prominence to the objective purpose. So we should interpret enactments in a way that advances Israel as a Jewish and democratic state. Now, this kind of power was crucial for Barak when he later on makes some of the most important revolutions. So for example, United Mizrahi Bank, it's only an interpretation question, right? Are the basic laws a constitution? This is a matter of interpretation. Human dignity, does it embody equality? That's a matter of interpretation. Okay, so with that tool in mind, the next revolution is actually the reasonableness revolution. And this is in 1980. This is the Yellow Pages decision. You have the Israeli Broadcasting Authority. It had a monopoly over TV broadcasting in Israel, and it decided to renew a contract for a decade, a 10-year contract with a private company to provide it sole advertisement services. No check of competing offers, no attempt to, get a better deal. Is it a reasonable decision? Probably not. But Barak does not intervene. Barak leaves the decision intact. The result is denial of the petition. But in terms of reasoning, a revolution. Barak states that every government decision must be reasonable. Every administrative decision must be reasonable. To soothe the fears of the other political branches, Barak states, you have a range of reasonableness, and within that range, with the court, we will not intervene. And the court states, you know what, maybe not every unreasonable decision will be illegal. Maybe only extreme unreasonableness. We know that later on, the court intervenes mainly, it's enough to be an unreasonable decision to intervene. And what is important is to understand what the reasonableness standards mean, that the actors must weigh all relevant considerations, only relevant considerations, and must give them proper weight. This is not math, right? This is a normative evaluation. Again, a lot of room where the court can intervene. Till that decision, sometimes the court used the language of unreasonableness, but it was never a sufficient basis for intervention. The court would say, it's unreasonable and it's arbitrary. It's unreasonable and there is no authority. It was never unreasonableness alone. And this was crucial for the next revolution. Now, I want you to understand also what was happening with the other members of the court. So Barak did not master a majority to the reasoning in the following sense. President Landau sits on the court and he actually says explicitly, I do not agree. This is not the law on the subject. And if it were the law on the subject, then we should accept the petition. And Ben-Porat states, Justice Ben-Porat states, I don't know, I'm inclined to agree with Barak, but I don't need to decide because the petition is denied. Okay, later on that becomes the law. And by the way, I'm not yet addressing questions. I will address later on at the Q&A, so I can actually be within my timetable. I was allotted a certain time, so I want to keep within that time allotted to me. So I apologize, but later on I'm game to questions. Okay, so reasonableness was crucial to the next major revolution, and that is 1988.
No one's rushing you, Rivka.
Okay, but I see some questions in the chat, but so I apologize. I will stay as much as it takes. I would be happy to entertain questions. I just want to put the story together, and there's also a limit to how much people can listen to a story. So I want to say only the most important things and then leave the others to the Q&A. So in any case, that actually sets the stage to the next major revolution. And that is the revolution of justiciability and standing. So you remember the ultra-Orthodox man's story, right? So people have been petitioned to the court forever. And until 1988, when the cases were brought in front of the court would say, I empathize with you, but I cannot entertain the topic. You don't have standing. Why don't you have standing? You are raising an issue that is no different than your grievance is no different than the grievance of the public at large. You have no standing. You cannot bring the case before the court. Or the court would state, the issue is not justiciable. It's a political question. This is for the other branches of government. I'm not intervening. But in 1988, the outcome is no intervention, right? We remember already, this is the strategy, these are the tactics, no intervention. But Barak writes the first opinion, and he states there the following, that if the issue involves a rule of law matter. And especially if there is no petitioner that has a more specific grievance at stake, the court is going to entertain the topic. He actually broadened the standing doctrine, and later on it became the public petitioner, and that any public petitioner can raise an issue of public grievance, of rule of law issues in front of the court. Now you have to understand the meaning of that decision, because the court is not like a political player that, you know, the members cannot wake up in the morning and decide, you know, I want to tackle this issue or that issue of Israeli society, right? The court has to wait for issues to arrive at the court. But if I allow public petitioners, the court becomes almost like the politician that wakes up in the morning and tackles an issue. And this is especially so when you take into consideration the unique nature of the Israeli Supreme Court. Because the Israeli Supreme Court sits at the High Court of Justice.
Levi, can you pause for just a second?
Yes.
There's a request that you raise the volume
of
your microphone.
Yes, I will try. Okay, I hope that does it. You let me know if it doesn't. So in any case, so the Israeli Supreme Court sits as a High Court of Justice. And that means that...
That seems to work.
Thank you. And that means that citizens can petition the court directly. They do not have to go through the lower courts. So if I want to actually challenge a government decision, if I want to challenge the constitutionality of a statute, I go directly to the Israeli Supreme Court. So then the court becomes almost like the politician that wakes up in the morning and decides, I can entertain this topic or that topic. And that landscape totally changed. Today, when I teach constitutional law, I teach primarily decisions of NGOs. The name of the decision bears the title of an NGO that petitioned the court. It became worthwhile for organizations to have staff that specializes in petitioning the Israeli Supreme Court, and this is how you affect public agenda. You don't necessarily have to go through the Knesset. Okay, in addition, in the very decision, Barak also makes the justiciability revolution. So what he says is the following: we should distinguish between normative injusticiability and institutional injusticiability. When it comes to normative injusticiability, when it comes to the question, do we have a law on the topic? Is there a norm to apply? Barak states, no black holes. I cannot envision a situation where the law does not have a norm, does not have what to say on the topic. And why is that so? Because if there is no other law on the subject, we have the reasonableness standard, right? I can always ask myself the question, is the government decision reasonable? If it's not reasonable, it's not legal. So this is how the previous revolution was crucial to this revolution. And later on, by the way, reasonableness became proportionality. But Barak did want to save, you know, to keep a small room for the possibility of injusticiability. So he states, you know, institutional injusticiability may be relevant. Maybe, I cannot envision, I don't know, but maybe there are cases in which the issue, if the court intervenes, then the court will lose the confidence of the public. And in such cases, maybe the court should not intervene. So maybe there are cases where the court should not intervene because then it would lead to loss of confidence of the public. But I myself cannot envision such a situation. I leave it for future judges. Now, you have to understand that that's how the court becomes a major political player. And that sets the stage, the standing revolution, the justiciability revolution, sets the stage for United Mizrahi Bank. Now, when I look at the other justices on the court, in the Ressler decision, they were not in agreement with Barak. Shamgar, the president, was sitting in the panel, and he stated, you know what? If the dominant issue is political, either court should not entertain the topic. And Ben Porat, who sat with him in the panel, said, I don't want to see the public petitioner as the regular petitioner. But it didn't matter. He didn't have majority in that decision, but his becomes the opinion of the court later on, and with no renewal discussion of the issue. And the next major revolution is 1995, United Mizrahi Bank. So the big question is, why 1995? Why not beforehand? Why then? So we have the story of the agricultural sector that suffers from heavy losses, is about, on the verge of bankruptcy. And the government decides to help the agricultural sector. But it decides to help it, not by funding it from public money, but actually by reducing the debt to the private creditors, and primarily the banks. Okay, so they actually sue. There is a civil dispute, and in that comes the question of constitutionality. So the decision is an appeal decision, and the outcome is no remedy. The banks do not get what they want. But the reasoning is that the basic laws amount to Israel's constitution, and the court has judicial review power over primary legislation. Now, the court is unanimous that the court has judicial review power, but there is a great debate on the theory of why the court has judicial review power over primary legislation. But it didn't matter in that decision, because the outcome was denial, no remedy. So this is, again, Barak doesn't have a majority in reasoning, but it helps cement in the public mind that his opinion is actually the opinion of the court. Now, why 1995? So you have to understand that Israel always envisioned that it will adopt the constitution. The Declaration of Independence commits to adopt the constitution. And this was part of the obligation of Israel to the United Nations. This was the plan, but we never acted according to the plan. The War of Independence broke out. The Constituent Assembly becomes the first Knesset. It adopts the Harari resolution that actually states that the Knesset will adopt the Constitution as basic laws in stages, and ultimately, those basic laws would consolidate to a constitution. But what is the intermediate status of the basic laws? No explanation. When will they be consolidated? No explanation. It was a compromise, and on purpose a compromise, because there was no agreement to adopt the constitution. Now, between 48 and 1992, we have basic laws that deal with the structure of government, basic law president, basic law the government, basic law the Knesset. We have no basic law dealing with constitutional rights, not because we didn't try to adopt the Bill of Rights. There was no consensus, no agreement. In addition, the basic laws passed just like any regular statute. And the court treated the basic laws typically as any regular statute. 1992, member of Knesset Amnon Rubinstein, in a brilliant move, comes with the following strategy. Let's tear apart the Bill of Rights. Let's have segments of a Bill of Rights, and let each segment have its day in front of the Knesset. Maybe some will pass, some will not. Basic law, human dignity and liberty passes. Basic law, freedom of occupation. They were passed with slim majorities. They were passed in a caretaker situation, caretaker government, caretaker Knesset. The members of Knesset were electioneering. They were trying to win elections. They didn't care about what's happening in the Knesset. But that was the hook, that was the anchor of the United Mizrahi Bank decision. And you have to understand that those basic laws do not embody equality. They do not embody freedom of movement within Israel. They do not embody freedom of speech. They do not embody freedom of religion, because there was no consensus. They do require the actors to act with proportionality. And this is the anchor for the United Mizrahi Bank decision, where the court decided, now I have the opportunity, let's declare that the basic laws are Israel's constitution. Let's seize the moment and not let it pass away. The last revolution I want to discuss is actually the equality revolution. So we are on the eve of the retirement of Aaron Barak. And the question of the draft of ultra-Orthodox men comes again before the court. And the petitioners are now challenging a statute that defers the service of ultra-Orthodox men to the army. And the court, again, leaves the Haredi community at home. No one is drafted to the army. But Barak states in the opinion that human dignity includes equality. Now, you have to understand why equality was not included explicitly. So the ultra-Orthodox political parties or the religious political parties more generally, they did not want equality. They wanted marriage and divorce law according to Jewish Orthodox law, which means great discriminatory practices against women. There was a fear about the law of return and whether that would stand a test of constitutionality. So equality on purpose was not part of the basic law. But Barak, on the eve of the retirement, incorporates equality nonetheless and interpretation method, interprets human dignity as including equality. Human dignity becomes the major engine of constitutionality in Israel. This is the basic law, human dignity and liberty, is the main way through which we review constitutionality of statutes in Israel. Okay, so I want to speak a little bit about effectiveness and legitimacy. So why were those revolutions effective? Why was Barak such an effective strategic judge? And I want to suggest a few explanations. So first of all, he was operating at a time when the political actors could view themselves in the opposition. So sometimes we had right-wing political parties at the head of the government. Sometimes we had left-wing political parties at the head of the government. Now, when you can view yourself as a political party in opposition, it is easier for you to accept a strong court because you understand that one day you will need the protection of the court. But when you are always in power and you cannot envision yourself in the opposition, then a strong court is only a barrier to achieving your political aims. So Barak had a more comfortable political landscape in that sense. In addition, Barak was actually serving during the difficult years of the Intifada, the first and second Intifada, during the time of the rise of the International Criminal Court, during the time that many countries already adopted universal jurisdiction for war crimes. You had politicians and you had generals worrying about entering airplanes, flying abroad, and being indicted for war crimes. They understood that a strong court actually keeps their back. And Barak made sure in the various decisions to state, this is in accordance with international law, this is in accordance with the trends of comparative law. He made sure to utilize that need. In addition to that, Barak was the long-term player and the politicians were the short-term players. So Israeli governments lasted on average 22 months during Barak's reign on the court. And this is because of the nature of the Israeli legal system, a parliamentary system. We have a parliamentary system with a proportional representation election method. So you have coalitions governing, and small parties can lead to the fall of the government. You have instability of government rule. So when Barak was actually deciding and actually denying the petition, he was not upsetting the current administrations, he was not upsetting the current legislatures, and because of the nature of instability in Israel, future governments, future legislatures, they were not in front of the court. He was the long-term player. In addition, sometimes I compare this to the invisible gorilla experiment. So you tell the audience, you instruct the audience, you should count how many times the ball passes from one player to the other. This is how you're measured. Did you count correctly? And the audience is so busy counting how many times the ball passes from one player to the other that the audience does not notice that there is a gorilla, a huge black gorilla coming in and out of the picture. And in some sense, the political branches were so busy with the hot issues of the days, with the outcome. You know, they were so concerned that, you know, the court would coerce them to draft the ultra-Orthodox men, that the government will fall over that issue. That when the outcome was no intervention, they sighed in relief and they did not fully grasp the meaning of the decision. And only later on, it doomed upon them, you know, we are living in a different landscape. Okay, so this is some of the reason why it was an effective jurisprudence, and that on top of the fact that, you know, he's a brilliant judge, and all the decisions are full of knowledge of Israeli law and comparative law, international law. Okay, why were they legitimate? Why were tactics legitimate? So I want to suggest that many of the revolutions that I'm portraying are actually revolutions in doctrines that originated in common law. And this is why it's expected that the court is going to be the one to change the rules of the game. Like in Israel, why did we have the restrictions of standing, of justiciability? The court imposed it on itself, on prudential grounds, to protect itself, defense mechanism. So if the court doesn't feel it needs those mechanisms, the court can waive those mechanisms. Reasonableness is a doctrine of administrative law. Right? It's a basis for intervention in administrative decision, reasonableness, proportionality. In Israel, almost all of administrative law is common law made. We barely have statutes. It's all the court making administrative law. So it's obvious that this doctrine will come from the courts. Now, interpretation, you have to understand that what type of interpretation do I use? Right? What method of interpretation do I use? This is a common law matter, even in the US, right? The judges decide what type of interpretation method do I use. So even in that sense, this is a common law doctrine. We have to understand that, at least in my mind, Barak never stated it this way. But to my mind, from Barak's perspective, this is how I understand his jurisprudence. From Barak's perspective, parliamentary sovereignty is a doctrine that originates with the court and can also be restrained by the courts. Meaning, why is the legislature sovereign? Because the courts recognize the legislature as sovereign, and the courts can also put limits on that sovereignty. Now, obviously, interpretation is a very strong, potent force. I'm not in any way diminishing from the power of interpretation, the reverse. In other writings of mine, I suggest that sometimes interpretation is a much more powerful tool than invalidation of statutes, right? Because interpretation, is it aggressive, is it not? This is in the eyes of the beholder, but invalidation, it's clear, right? A court invalidated the statute. And Barak was smart. He used mainly the power of interpretation. He used mainly the power of administrative law. He barely invalidated statutes. There are like 5 statutes or provisions thereof in an 11-year period, 5 invalidations during the Barak's term. I want to talk a little bit about the current court, and with that I'm ending. The current court is playing a very different game and is encountering a very different political situation. The current court, actually since the retirement of Barak, there were 4 presidents on the Israeli Supreme Court. They came primarily from being previous judges on lower courts. They came primarily from the executive branch, from being private attorneys. They did not come from academia. The court faces a very different political situation. Since 2009, you have Bibi Netanyahu as the Prime Minister of Israel. It's a government that can more easily try to restrain the judicial branch. And the court plays a different game. The court tripled the pace of invalidation of statutes. Within 14 years, we have many more invalidations than during Barak's term. I think it's already now 16 or even more since Barak's retirement. Now, in addition to that, and this is important, by the way, because many people say, you know, the court is frightened, the court feels restrained. No, the court is powerful, the court is strong, the court invalidates statutes also in hot political matters. and not always does it act in a strategic manner. So for just as an example, within a 2-year period, the court invalidated 3 times statutes that dealt with detention of people that entered Israel through an unrecognized border. Now, this is an important human rights issue, detention, liberty, but in none of the decisions did the court actually require the political branches to decide who those people are. Are they refugees? Are they economic migrants? I don't know till this day. No one knows. So using the power of the court in a more strategic way, invalidating a statute once, but requiring accountability from the political branches would have been much more a Barak's move than the move of the current court. The court did act much more strategic when it comes to Netanyahu, by the way. So I want to conclude that I think that Israel must have a strong court. It's a young democracy after all. It's a pluralistic society. We have perpetual minorities. And the court's power is not protected enough, right? To change the jurisdiction of the court, to change the structure of the court, you can do it by 2-to-1 decision. There's no entrenchment. And the political actors and the court must be very careful about their game in order to protect this asset of Israeli society. And I would urge the judges also to understand Barak's legacy, not just a legacy about substantive law, but also a legacy about tactics and strategy. How do you promote agendas while at the same time maintaining public confidence in the court? Thank you so much.
Thank you, Professor. We have some great questions, but I had to ask you one. You clerked for President Barak. What lessons did you draw from doing that? How has it affected your life and career?
Okay, so Barak, I'm very close to Barak. He's a special, unique human being. He's a very warm person. He's a people's person. It's like you are in front of a person and he's so human, and at the same time you know that he's so giant in terms and brilliant in terms of his understanding and scholarship that it's breathtaking. So I feel very privileged to have been able to be influenced both on a personal level and on a professional level. I'm deeply honored, and it obviously affected also the way I think, the way I write. I came to him at a very, very young age, and he's very close to me.
Well, thank you. Well, Horowitz asked a couple of questions that I'm going to try to consolidate. Is purpose of interpretation good? Should the courts have entertained other theories? And does the court, when it abolishes justice, stability, and standing, and relies on reasonableness, arrogate to itself too much power over the political branches, or the political branch, I should say?
Okay, so let me start with
that's a nice, easy question, isn't it?
Okay, so let me start maybe with the justiciability, and there are actually the question couples so many issues. I do hear some return of rhetoric of injusticiability. Some of the justices, for example, in the Netanyahu decision, prefer to say that the issue is non-justiciable rather than we deny the petition on the merits. So you do hear, and the court has been able to construct other tools to actually remedy for the fact that it has no working injusticiability doctrine. So for example, ripeness. Is the issue ripe for decision? Became a major doctrine in Israel after the justiciability revolution, actually after Barak's retirement. So what the court does when it feels that it cannot deal with the issue, it argues that the issue is not ripe for decision. So for example, if you look at the Netanyahu petitions, there were so many petitions before the court finally tackled the matter. And the court decided actually the timing of the decision. So by the way, in a way, the ripeness doctrine became a doctrine that enhances the court power in a way, right? Because you now determine the timing of the decision. You time it to the exact moment when you feel comfortable that you can give that decision. So the court does try to compensate for the lack of a working doctrine of justiciability. So because justiciability in essence is a doctrine that is intended to protect the courts more than anything else. Now, in terms of reasonableness, I think that by now reasonableness, proportionality is also required under our basic laws. So if in the 1980s it was only a doctrine of common law, and now it's embodied in the basic law. The big questions are the questions: should it be reasonableness alone? Should it actually be extreme unreasonableness? The questions are: should we incorporate a deference standard, right, vis-a-vis the administrative branches? So there are ways to mold the reasonableness doctrine. I don't see how the court can totally discard with reasonableness at this point. There is a path dependence a matter, right? After that system has developed in this way for so long, it's very hard to make a turn, and I don't expect it to do so. I expect it to develop doctrines to soften the effects of reasonableness. But there are also attacks on specific areas of the law. So for example, on the issue of impeachment of public officers, there are great challenges. Should the court actually overturn its previous decisions and actually not intervene in impeachment decisions? And the impeachment intervention is based on reasonableness doctrine. So I'm seeing a situation where the court would remold the doctrine. About the nature of interpretation. So you do hear some different voices slowly. It's minority opinions. It's in the margins of opinions. But you start hearing different voices, especially with conservative judges. Interpretation is tricky. Interpretation is tricky the more you actually read into the statute something that the legislature never intended, and we also have evidence that actually the legislature meant otherwise. So I think over there too, there is more that can be done to be more proportional about purposive interpretation, right? Taking to a greater extent or giving greater value to the legislative intent without discarding with purposive interpretation. But it's a whole different topic. It's a whole different conversation. So I'm giving only a partial answer.
Well, a full answer would probably take a textbook at least, maybe several textbooks. Question about whether Israel, from Richard Fulton, about whether Israel has civil rights laws, and I'll combine that with a question from Alan Washington about the relationship between the declarations in the Declaration of Independence and the basic laws. In other words, where is the authority for enforcing equality? Is there authority in any positive law passed by the Knesset? Is it in the Declaration of Independence, or is it purely in the basic law?
Okay, so the status of the Declaration of Independence is an interesting question. Barak treats it as one of those lost opportunities to actually do more with text. Because during the early moments of the establishment of the state, the question came before the court, what status should be granted to the Declaration of Independence? And at the time, the court treated it as a nothing, right? It's not even a statute. It's an international law document, but it's not binding internally. Over time, it became an issue of interpretation, that you do use the Declaration of Independence as an interpretive tool. But in the basic law, human dignity and liberty, and basic law, freedom of occupation, you do have incorporation by way of reference to the Declaration of Independence. And it's an interesting story because Rabin and Shas This incorporation was actually done in 1994. And Rabin and Shas and Aryeh Deri, who were the architects of the 1994 revision of the basic laws, did not mean to have an incorporation to the Declaration of Independence. And they later were very upset with that incorporation. They voted, they raised their hands, they supported the basic law in the version of 1994, but ultimately did not know that it embodied an incorporation to the declaration. So the story of equality is not necessarily the story of anchoring it in the Declaration of Independence. No, I would not say so. The story is that in a way, Israel has a double nature or a contradictory a character in the following sense. Basic law, human dignity and liberty, has what we call a savings clause. It saves pre-existing laws, and pre-existing laws may not be invalidated by the court. So then what you have is you have an Israeli society, an Israeli landscape that is very conservative and non-liberal on security matters, on civil rights matters, with regard to old enactments predating 1992. But then any enactment that is after 1992, that is not under the umbrella of the savings law provision, that the court gives a liberal interpretation, democratic interpretation. And here is where the bite of equality really matters. So because you can invalidate statutes. Now, even old statutes, their interpretation is affected by democratic values, by liberal values, but you cannot really invalidate. So from my perspective, equality comes primarily from human dignity when it comes to the bite with regard to invalidation of statutes and with regard to its effects on the Knesset. But the Knesset did have equality statutes even before 1992, even before the basic laws. So we have a promise for equality to women already early in 1951. Okay, we do have equality, we have a statute that promises equality to women. So, but that is subject to religious law. So its effect is very curtailed. And it's subject to the needs of accommodation of the army. So equality is a very, it's a very difficult work in progress situation in Israel with regard to equality on all levels. Israel and Arabs relationships, women and men, and the different religious segments within, Jewish society, Israeli society.
All right, there's a couple more questions, particularly on the recent bypass efforts. And I guess we just circulated a survey that showed that 93% of the Haredi don't trust the Supreme Court, which relates to the bypass efforts. So rather than ask a specific question, just could you comment on the bypass efforts and the fact that you've got this huge block of influential people who don't like the court at all?
So by bypass, you mean override? You mean the legislative override? Okay, so actually the legislative override is a very interesting story because in many ways, the override is a natural development of Israeli constitutional law. Unfortunately, by the way. Before the constitutional revolution of 1992 or 1995, the Israeli Supreme Court invalidated statutes that contradicted Section 4 of Basic Law, the Knesset, which promised equality in elections in Israel. And what is interesting is that each time the court invalidated a statute for not aligning with equality of elections, the legislature would override the decision. And this is why we were an anomaly. We were a fully committed parliamentary sovereignty system, But we had a court that could invalidate statutes, but the invalidation meant nothing. Because, it was, the legislature then said, I do what I want, I override. And the court accepted it. It was legitimate. And it could be even a retroactive invalidation of statutes, a override of statutes, an override of the Constitution. The court had no problem with it. So override is actually very akin with Israeli history. It's very akin, it comes from the tradition of parliamentary sovereignty systems that want to protect individual rights. Now, if you are a parliamentary sovereignty system and you do not have a constitution and you develop common law rights, right? The court recognizes rights, protect those rights, but if there is an explicit saying of the legislature, then the legislature wills prevail. That's how common law courts protected rights. So override is this idea. Unless the legislature does not force upon you the idea that it wants to override a right, the court will assume that it does not want, and it will interpret even in an aggressive way to protect rights. So unfortunately, at least from my perspective, override is very natural to Israeli development. I'm saying that it's unfortunate because I do assume that if the Knesset incorporates an explicit override, it will use it often and in a way that will diminish the protection of rights in Israel. Now, I want to say just one more thing. According to some justices of the Israeli Supreme Court, there is already the power of override. The legislature already enjoys the power of override. Some of the justices on the Supreme Court, this is primarily Justice Cheshin's opinion in United Mizrahi Bank. Some of the justices believe that basic laws can protect rights, but that an explicit override will prevail. And this is even with no incorporation of an explicit override clause.
Well, it was just a follow-up question on this from Stephen Greenwald about apparently President Barak said if there was sufficient high majority, supermajority in Parliament to do an override, he would have no objection to an override clause. In other words, rather than 60,
okay. So this
70 or 75, do you have any thought on that?
So this is very interesting because on the one hand, you hear a very principled debate, what should we have or an override, should we not have an override? And then suddenly diminish into a tactical debate or, a mechanistic debate. What should be the size of the majority? Now, from Barak's perspective, it's not just a matter of the supermajority, right? Barak wants it to be part of a package. We never enacted basic law legislation that will actually finalize the constitutional enterprise. And Barak really wants a final date, right? That it will not be a continuing process of enactment of basic laws. Right now we have basic law nationality, a new basic law. It's only a chapter, right? It's a chapter that should be read together with the other chapters. But the Knesset can continue forever, supposedly. So Barak's idea is to have a package. And in that package, you will have recognition that the court has the power of judicial review, an explicit recognition. And you will have an entrenchment of the entire basic law enterprise. And as part of the price that Barak is willing to give for such a package, he's willing to have an override. And then comes the question of the size of the majority. Now, if you look at Canada, that has an override, and if you look in general at the history and comparative history of override, it does not typically come with supermajorities. The idea is, as I told you, it comes from the common law systems that the legislator will should ultimately prevail. Now, I understand from where the supermajorities come, because they come from the idea that coalitions, as is, master 61 members of Knesset. So you want more than a mere coalition to amend the basic laws. But you should remember that in Israel, coalitions now already, it's a matter of practice that members of the coalition require a veto on amending basic laws or enacting basic laws. So if we have a situation where members of the coalition make it into a practice that they demand a veto on the use of the override, that would be actually a much more influential device than having a supermajority for an override. And I'll tell you what is my concern about the supermajority of an override. I do not want in any way to make the override a more cumbersome process than the process of enacting or amending the Constitution. Because I do not want to give an incentive to amend the Constitution rather than override. From my perspective, there are many. I wrote now an article in Hebrew, and I'm going to do an English version. I wrote about the inherent limits on the override power. I believe that I developed many inherent limits on the override power, and I think that the override power is a temporary mechanism, and ultimately it lapses. And this is inherent in the nature of an override. But when you amend the Constitution, it stays with you, it sticks. So I don't want to create a situation where the incentive goes to amend the Constitution rather than override the Constitution.
Draw an analogy that if there were ever a move to abolish the First Amendment in the United States, how would you deal with that? We have about 5 more minutes, Uri, am I correct in that?
Yeah, we shouldn't stretch it. I see that people are signing off because they have probably planned on the next program on their schedule.
Well, I had one very lawyer-like question from Mark Anshan, which was, if you use reasonableness, are you undermining the ability of lawyers to advise their clients as what the law will be? You know, some office wants to know whether they can do X or Y. If the judicial test is reasonable, how are they going to know what to tell the client?
This is, the reasonableness affects administrative bodies. It affects government decisions. It does not affect the private sector. There's no requirement that the private sector will act with reasonableness. I don't see any problem in that regard. You can ask me a different question. If purposive interpretation is the method of interpretation also in private law, then that actually is very problematic when it comes to interpreting contracts or interpreting transactions, like, because it brings great uncertainty. Doesn't matter how explicit you may be. If the court reads what it wants into the contract, then, you know, that's a problem. So this is why purposive interpretation works very differently in the private law sector. There is, I think, a gap between what the judges say they do and what they actually do and how the private sector actually behaves. I think there is much more of an attempt to try and stay loyal to the original intentions of the drafters of the document than to objective standards.
Okay. I'll just throw this out briefly. Couple of questions, Rabbi Schachter, about the Yellow Pages opinion. Why didn't it overturn the sole source contract? And then there was another specific question about private prison case was kind of very strong assertion of judicial authority. If you can comment on them briefly, fine.
Okay. By the way, I hear you coming in and out, but
okay.
But, no, but I heard. It's fine. Thank you. So, with regard to the prison issue, the prison issue is a very interesting case. It was decided, you know, that Israel tried to privatize prisons in Israel, and ultimately the court decided that privatization should not be allowed. And this was after the court already, after the private company of Lebayev actually built the prison. So you had a standing building, you had already all the money put into it and ready to work. And then the court decided, wait, you cannot privatize it. Now, the court based the decision actually on human dignity. And the idea was that the very idea, even if de facto my human dignity is actually more protected if I am in a private prison, because they give me more opportunities for rehabilitation. They give me a bigger cell. So actually my human dignity is more protected. The court stated that the fact that you are being held by someone, private people, and in order to actually profit from your continued incarceration, that is actually against human dignity. Now, this is a very, this is a very debatable, right, a proposition, right? It's not so clear and obvious, right? Actually, the minority judge, Levy, who was an extreme, he cared a lot about social rights, and he wasn't, he didn't agree with that decision. Now, what the court should have actually, what the court meant to do, but he didn't know how to do it, was to suggest that there are limits to privatization based on structure of government issues, that there are certain issues that the government cannot privatize. Now, and it should have been on the nature of that. What is the executive branch? What is the government? What can it delegate or privatize to the private sector and what not? Now, why didn't the court base its decision on that? Because it didn't know how to use the limitations clause when it comes to the issues of structure of government. Like, it didn't know how to use proportionality with regard to such questions, while it was easier for it to use proportionality with regard to human dignity. So it's like a technicality, but this actually affected the reasoning of the judges. It's a very foreign to American ears, right? If you think about the bail system in the US, if you think about the privatization in the US of the whole incarceration system, then it's hard to understand the Israeli decision.
Well, that's a subject for another whole text.
Right, but I need to also answer the reasonableness, right? So I will answer briefly the reasonableness, but I can't talk about it. You're right; it's very interesting. Okay. About the reasonableness, I think Barak, as I tried to explain to you, but first, Barak did not master a majority. I'm not sure that had he pushed through and he would have stated, you need reasonableness, and I apply now the standard, and the contract is unreasonable, then he may have been a minority opinion. And that would have affected, right, the long-term legacy or the long-term achievement. And this is especially so that you have to take into account that the revenues from that contract were around 10% of the revenues of the Israeli Broadcasting Authority at the time. So it would have upset greatly the political branches. So I think he didn't have a majority. And also at the time, Israeli law was quite different on the subject. It was only beginning. We don't have until the 1990s a requirement that you should actually hold, that you should have a competitive process before you assign an administrative contract. So this was not part of Israeli law. So you didn't have a statute on that. It wasn't part of Israeli law. And he was making already one big revolution, the reasonableness revolution. This is how smart he was. He paced the revolutions in a way that both his colleagues could digest and the Israeli public.
All right. Well, I want to, at this point, thank you for another wonderful presentation. We were so grateful to have you with us and take up your time, enlighten us on a whole variety of constitutional topics. Israeli constitutional in a nutshell. Thank you so much, and I'm really appreciative, and a very warm appreciation for your giving us the benefit of your thoughts. I'm going to turn it back to Uri for a moment for his conclusion.
Thank you, Peter.
Again, thank you.
Professor Weill, this was brilliant, and really, I'm putting myself in the shoes of your audience tonight or this afternoon, and clearly you have provided them with an ability to understand one of the more complex issues that, as you pointed out, differentiates between Israel and the US. So I'm sure it's been a wonderful experience for everybody that was with us, and for others who will watch it as the recording becomes available. 3 very brief points. One, you mentioned the 92 Basic Law on Human Liberty and Dignity, but this sort of should be seen in the context of our focus on issues of religion and state. What this was derived from, as you pointed out, it was the, I think, brilliance of Professor Amnon Rubinstein, who took a chapter of a previous draft, which was a much more comprehensive draft. It was intended to be Israel's Bill of Rights, It was prepared by Dan Meridor of the Likud when he was Minister of Justice. And the reason I'm mentioning it is that as soon as he made it known in public that the Ministry of Justice was working on what was labeled the basic law on basic rights of man, or basic human rights, he was attacked effectively by the ultra-Orthodox parties, who basically said Judaism is incompatible with the concept of civil rights, and therefore we will not allow a Bill of Rights to be passed by the Knesset. And their political cloud then, and the previous chapters and the subsequent chapters, has denied Israel to date of a Bill of Rights. And of course, and we won't be able to deal with it, the question of what happened, as you described, with this one chapter, and how Barak basically stretched it to cover so much more than it was understood to mean, we'll leave that for another opportunity. Two, Barak's brilliance in presenting and interpreting the basic law as a constitutional revolution resulted with repeating threats on his life that were received at the Supreme Court and brought about something that was never thought it would happen, and that is guards were assigned to protect his life. And since then, the Chief Justice has now been accompanied by guards, by bodyguards. And it would not surprise you to know that these threats on Barak's life, identifying him and subsequently describing him, occasionally in terms of a Satan, came from fundamentalist religious circles. And again, the clash of religion and state, and as you presented it so well, over the rule of law, is closely associated with the battle of religion and state in Israel. And the last, and it's sort of a comforting thought, with the assaults on the Supreme Court that are mounting, repeated polls are indicating that even though there is so much criticism that's waged from political and fundamentalist religious circles, still the trust level of the public in the Supreme Court is 4 times or 5 times higher than the level of trust that the public has in its political leadership, namely Knesset and government. And inasmuch as erosion has taken place in the public attitude towards the courts, it still is so much higher than the politicians who are attacking it and who are trying to pull the rug from under it, that we should draw some comfort. Certainly, it's a very volatile situation, and you have described it so well, both in your previous lecture and in this lecture. But I thought that this would just provide a bit more context. And before we sign off, I mean, do you feel that I mispresented any of those points?
I want to be careful about the ultra-Orthodox community. There are many, good people, there are many. I think what happened on the court is also that the United Mizrahi Bank decision was given in November 1995. It was given a few days after the assassination of Yitzhak Rabin. And that is not because of, this was poor timing because they had no other choice in light of the fact that Shamgar was the president of the court and he had to retire. So in order to have him sign a decision, it had to be delivered at the time it was delivered. So I think part of the whole security landscape with regard to major figures in Israel changed following the Rabin assassination. So I want to give I want to give a greater context to the very volatile political situation that we are facing in Israel. Obviously, there were also major demonstrations against the court and by religious sectors following some of the decisions, especially with regard to Orthodox men, but not just, on conversion issues and other issues. So in that sense, I'm with you. I wanted again to thank Judge Buxbaum for this amazing opportunity and for actually reaching out to me at the time after reading my article. Really, thank you so much, and Uri, and to all of you. It has been a great honor.
Thank you, Professor Weill. I hope that we can impose on you and invite you back, because you left in as much as you provided us with rich contents and understanding. There are so many issues that you opened up, and we would love to hear more about it as we move forward. And please stay tuned. You'll be receiving information about the upcoming webinars on Jewish theocracy, and it's sort of connected, the battle over Jewish theocracy then and now, and feminism, COVID-19, and religion and state in Israel. So thank you so much. Shalom to all, and hopefully we'll see you all in 2 weeks.
Shavua Tov.
Alex K's presentation. Shalom and good day.
Okay, thank you.
Thank you.